Okay, Chapter 26, Part 3, Real Estate Sales Contract. The sale of real property is much more complicated than the sale of goods and involves more formalities. Because of the statute of frauds, it has to be in writing. So usually the parties enter into a contract for the sale of real property after they have engaged in substantial negotiation. The contract is going to include things like the purchase price, the type of deed the buyer will receive, the condition of the premises, and any items that will be included in the sale. In Georgia, it has become much more specific in terms of these contracts. Almost always the contract that's used is the one that has been developed by the State Realty Association, and it's a form contract, and most realtors are going to use that. And it now provides a full set of disclosures by the owner that they have to answer. For example, have you ever had any water damage in your basement? Things like that. Have you ever had any mold? All those kinds of things. So it's a fairly involved contract now that is used in these transactions. In addition, most people who buy real property do not pay cash for it, but instead get a lender to lend them a certain amount to buy the property and give a mortgage to that lender for purposes of securing that debt. The closing date and escrow. The closing date is the date on which all the paper will be signed and the transaction completed. During the process of after the contract is signed until the closing date, all the financing arrangements are made. The title is searched by title searchers and lawyers who make sure that the seller actually owns the property and that there are no what we call encumbrances on the property, no liens or no other deeds that would affect the property. The deposit that the buyer puts down is held in escrow. That is an account that is secure, that no one is allowed to use except for the purpose of the closing. Okay, so the seller has to have what we call in the law a marketable title. That means a good title, meaning that they own the property. That means that the ownership is free from encumbrances except those that are disclosed to the grantor. Most property has some type of encumbrance, whether it be a easement or something of that nature, and that has to be disclosed. What we don't want usually is things like liens. Those create problems. Title insurance is the best way for a buyer to ensure that if there's any defects in the title, that they will be covered for any losses that happen. So, for example, if the property wasn't actually owned by the seller because of some mistake in the previous titles, title insurance would cover that individual. Okay. Implied warranties in the sale of new homes. Under this warranty, the seller of a new house warrants that it will be fit for human habitation, even if the deed or contract of sale does not include such a warranty. I don't believe that Georgia has this type of warranty. However, most of the time, sellers, particularly sellers of new property, will give a warranty of the property for a certain period of time. And the seller has a duty to disclose hidden defects. I already talked about this in Georgia. It's much more extensive now in that you don't just say, I'm not aware of any hidden defects. You have to answer a series of questions that are on a number of pages that is much more involved and specific. Okay, let's talk about deeds. Deeds are the instrument that's used to transfer possession and title of land from one person to another. Deeds have to have these things in them: the name of the grantor, that's the seller or the giver of the property, and the grantee, the donee or buyer. They have to have words evidencing an intent to convey the property. No specific words are required, just enough to evidence the intent to convey. There has to be a legally sufficient description of the land, including metes and bounds. Property is described by what are called metes and bounds, which are measurements going in certain directions. And usually the description will say starting at certain point and then going northeast so-and-so amount, so-and-so direction, and then going so-and-so. Much of land is dependent upon things like stakes that are put in the ground, or distinct things on the property which mark where you start and where you go. Obviously, these things can create problems because things like stakes get moved, and then you have issues of who owns what because the descriptions may not be accurate. I predict, and I may be wrong about this, but I predict sometime in the future we will abandon that method completely, and we will go to the use of global positioning. Global positioning is used a little bit now for some purposes, but it is probably more accurate because you're not dependent upon a landmark such as a stake or a tree or somebody else's house or something of that nature, and so sometime in the future that's likely to occur. There has to be the grantor's and usually his or her spouse's signature, and then the delivery of the deed. The highest form of deed, or the best form of deed, is called a warranty deed. It contains the greatest number of warranties from the seller to the buyer and provides the most extensive protection against any defects in title to the property. It usually includes these covenants, which are promises: a covenant that the grantor has title to and power to convey the property; a covenant of quiet enjoyment, that is, use of the property without any interference; a covenant that transfer of the property is made without knowledge of any adverse claims of third parties. Okay. There's also what's called a special or limited warranty deed. This warrants only the grantor or the seller to have good title during his or her ownership of the property, and does not guarantee that there are any adverse claims by any third parties against any previous owners of the property. A common type of deed in some situations is a quitclaim deed. A quitclaim deed basically says that the person is transferring whatever interest they might own to the other person, but not guaranteeing any kind of ownership. It offers the least amount of protection against defects in title. If the grantor had no interest, then the grantee receives no interest. Quitclaim deeds are often used to clean up a title to property where there may be clouds on the property. For example, in Georgia, particularly in rural areas, many years ago, people owned many acres of land, let's say 200 acres of land. They died, they did not leave a will. They may have had 5 children. All children received an equal amount under the laws of intestacy. Then, over the course of time, the land passed to the grandchildren, the great-grandchildren, etc. Nobody ever recorded deeds or ever used wills or any other method to properly transfer the property. Now you're in modern days and you're trying to make it so that somebody can actually sell the property. So oftentimes what you do is go and get quitclaim deeds from anybody who might be an heir to the property to clean up the title to the property. A grant deed is a deed where the grantor simply states that he or she grants the property to someone else. Now, recording statutes. Recording statutes are very important. You record the sale of property in the Superior Court where the property lies. It is recorded in what are called deed books. Deed books go in a progression of the time in which the deed is recorded. Then you have digests which tell you which deed book to go to. There's a grantor digest and a grantee digest. The grantor digest lists all the property by the grantor's name and tells you where the deed can be found and any other property records. The grantee index goes the opposite way and tells you by the grantee where you can find the property. This is to put the public on notice of a new owner's interest in the land. It prevents the previous owner from fraudulently conveying the same interest to another buyer. Now, Georgia and most states, the law is that the first to record is the actual owner. So if A sells property to B on day 1, and then A sells property to C on day 2, and C records the property before B records the property, C is the rightful owner. So it's very important that when you receive a deed to property that you have it recorded immediately to avoid any of these types of problems. Okay. Adverse possession we'll talk about in part 4 of chapter 26.